Welcome to Imagine IP. Today, we're diving into a case that has lasted longer than most people's gaming addiction to Candy Crush. It's Aristocrat Technologies versus Commissioner of Patents, a legal saga that has tortured many Australian patent attorneys. If you're a software patent attorney, it now might be safe to come back to the profession. So imagine this. You're Aristocrat. You've invented some fancy new features for electronic gaming machines. We're talking configurable symbols and feature games. These aren't the classic mechanical slot machines with spinning physical reels. We're talking about fully digital gaming systems where all the action happens electronically. Now, Aristocrat thinks, hey, this is pretty innovative. Let's get some patents. And initially, they do. 4 innovation patents, granted in 2016 and 2017. Life is good. The lawyers are happy, the accountants are happy. Aristocrat thinks, job well done. Who is buying the next round of drinks? But then the Commissioner of Patents shows up, like that roommate who tells you the party's over and they want to go to sleep. In 2018, they revoke all the patents, saying, nice try, but this really isn't an invention. You've just taken some gaming rules and stuck them in a computer. Outraged, Aristocrat goes to court in 2020. Primary Judge Burley says, nope, Commissioner, you're wrong. The patents are valid. It's a proper gaming machine invention, not just some abstract idea. Vindicated, Aristocrat is happy. The full federal court in 2021 says, actually, Primary Judge, you're wrong. They invent a fancy 2-step test, asking first, is it computer implemented? And second, is it an advance in computer technology? If it's not advancing computer tech specifically, no dice. The patents are invalid again. Aristocrat is sad. But here's where it gets really spicy. The High Court says, we will take a look at that. And we get 6 of Australia's finest legal minds in 2022 looking at this question. And what happens? They split 3-3! It's like a legal coin flip that landed on its edge. A rock, paper, scissors game where everyone keeps choosing rock. 3 judges say the patents are invalid, 3 say they're valid. Under some dusty procedural rule from 1903, Section 23(2)A of the Judiciary Act, when the High Court splits evenly, the lower court decision stands. The case gets sent back to the primary judge in 2024, who basically says, well, I'm bound by the full court's reasoning, so the patents are still invalid. So Aristocrat loses again, and they are sad, somewhat confused. But wait, there's more! Aristocrat, like teenage kid that wants 5 more minutes of social media time, appeals again, and this full court, the one deciding this case in September 2025, looks at everything and says something quite remarkable. You know what? All 6 High Court judges criticizes the 2-step test like an English teacher criticizing your wrong usage of there. The consensus? We shouldn't follow an approach that got universally canned. And here's the beautiful legal reasoning. If you had built these gaming features with actual physical cogs, gears, and mechanical reels, Iron Man style, everyone agrees it would be patentable. So why should replacing those mechanical parts with sophisticated software and hardware make it unpatentable? The law shouldn't punish innovation, but reward it. The current full court adopts what they call the allowing reasons from the High Court split. The test isn't whether you're advancing computer technology specifically, it's whether you're taking an abstract idea and implementing it on a computer to create an artificial state of affairs with a useful result. Think of it this way. If you just use a computer to manipulate an abstract idea, like a calculator app to automatically calculate how much of your food your roommate has eaten, that's not patentable. But if you implement an idea on a computer to create something new and useful in the real world, like these gaming machines with their fancy configurable symbols that enhance player experience, which leave them wondering what time it is, that's different. That's a manner of manufacture. After 7 years of legal ping pong, a new full court declares computer-implemented inventions can be patentable. Aristocrat finally wins. The real jackpot wasn't the money they could have made, but the legal precedent they established along the way. And the fact that their legal team can finally stop having recurring nightmares about manner of manufacture. So, that's all for now. Thanks for watching, and as always, keep imagining.